Hi, my name is Emily Morris. I'm an attorney with the Morris Law Firm here in Austin. I practice business and real estate law, and I am a participating attorney with Texas Legal. I've been licensed in Texas for 9 years, and I've had my own firm for 6 of those. My website is morrisbusinesslaw.com if you'd like to find out more, or you should be able to find me on Texas Legal's directory, and I'll be happy to answer your questions live during this webinar. So the typical order of operations for buying or selling a home goes through like 5 to 6 primary steps. The first and most important step is negotiating the contract. So this is the time period where you found a property that you're interested in, or you have an interested buyer if you're the seller, and you're working out, okay, how much are we selling this for? Who's paying for what? Any timelines and like financing and all of that is negotiated at the very beginning. If you're a buyer putting in an offer, it's important that you have a real estate attorney and or broker work with you to make sure the contract is something that you're actually familiar with and comfortable signing moving forward. Once the parties have worked out those terms and executed the contract, it gets brought to the title company. That's a company that's selected by both the parties along with earnest money, and then they will do what's called opening title, which is where they start the search process to check any property records that potentially affect ownership interest in the property. This could also be the beginning of an option period if that's something that has been agreed in your contract. This is a pretty short time period where you can bring in inspectors if you want, find out more information about the property, and still terminate within that option period and get your earnest money back if that's what you choose to do. Following this, the title commitment will issue. This is a document that the title company will put together, and it includes any issues of concern affecting ownership to the property, and will be kind of the preview to your title insurance policy. We'll touch on that a little bit more later. You'll want to review that and resolve any issues there. And then just before closing, you'll want to finalize, if you're taking out a loan, you'll want to finalize any terms of the financing with your lender. And then the last step is closing. This is the final meeting at a title company's office where everybody signs off. You sign off on the settlement statement, which is where the money's going. You get the deed from the seller, buyer signs any lender documents, etc. Then you get your keys and you go home. Yeah, so my key recommendations for sellers are honestly in this market, if you can stir up some interest in your property without paying a commission to an agent, that might be something good for you. The default is standard is to pay 6% to a broker to market and sell your property, and then share that 3% interest with the buyer's agent. That may be beneficial to you if they're driving up a bidding war. But if that's something that you're not that interested in, you say you already have some people that you know that you would rather sell your property to, you can save on that commission and hire an attorney to still review the contract and everything and help you negotiate that before it's signed. Even if you do have a broker, I still am going to recommend that you have your contract reviewed by an attorney. And those terms, a lot of those terms that I discussed for buyers, you're going to want to pay attention to. So things like who's paying for closing costs, who's paying for the title policy, if there's a new survey needed, who pays for that, any contingencies, option periods, all of these things. But you're just going to be looking at it from a different perspective. So in this particular market as a seller, you can be more demanding. You don't have to provide so many concessions as you might without as much negotiation power. But things can change. It won't always be this way. So some things that you can look at to entice sellers are providing some of those concessions towards closing costs, maybe a longer option period, things like that. You're going to want to, you have to fill out a seller's disclosure, but you're going to want to do this carefully and make sure that everything is accurate according to your knowledge. So a seller's disclosure is a document that's required unless you meet certain criteria, like you're selling to your parents or something like that. where there's a form that you have to fill out that basically describes the current state of the property, if any changes have been made over the course of your ownership. You are only required to answer to the best of your knowledge. So if you do know about something, you have to disclose it, but if you don't, you can't be held liable for that. The important thing here is just to be truthful so that you can't, if something comes up later, you aren't stuck in a situation of being accused of anything fraudulent. I always recommend selling the property as is. So the buyers have their chance to inspect it, and then once they do, then it's kind of take it in its current condition. Sometimes buyers will want to negotiate seller repairs, like if there's certain things that they want the seller to take care of before closing, and of course that's within seller's discretion whether to do that. But a lot of times, I do see that happening. Closing costs, we already talked about that, and then reviewing the deed and closing documents. So it's especially important for the buyer to review the warranty deed, but the seller needs to review it too. And make sure that the legal description matches up to what the title commitment has said and what your existing deed says. Make sure your names are listed appropriately and all of the above, so that there's no issues later that pop up for you once this property has been sold. So key tips I recommend for buyers that are entering the real estate market are, first of all, you're going to want to have some help negotiating the contract. Things that I would suggest asking for, if at all possible, are an option period, and make sure it's long enough to where you can actually have time to have an inspector come in and check out any potential areas of concern. Negotiate a financing contingency, again, if the seller agrees. The financing contingency is going to be included in a financing addendum if you're taking out a loan to purchase the property. And as a buyer, you do want this purchase to be contingent on financing, because without that, if it falls through and you don't have the money to come up with, the seller could, essentially enforce the contract anyway. Or they could decide that you're in breach of it and terminate, but keep the earnest money. So you're essentially forfeiting your earnest money. So if at all possible, you do want that contingency, and that's going to have a certain time period on it. I see like 14, 21 days, to where you have a certain amount of time in which to qualify for the loan. You will be in your best shape if you pre-qualify, and then hopefully that's not an issue. But things can still come up as this process progresses. You want to make sure that all the exceptions listed in the Schedule B of the title commitment are accurate in the first place. Make sure they apply to the property. Make sure they're still active. And if there's anything that really should not be there, or you think that the title company should cover anyway, or the seller should resolve, that you object to those and get those taken care of. So one key contract tip is, I always recommend, as a buyer, that you select the shortages in area amendment option that's listed in paragraph 6A of the standard TREC contract, otherwise known as survey deletion coverage. So the title company will give you additional coverage for your policy that isn't limited to what shows up on the applicable survey. It's usually a few $100s extra. Either you can pay for it as a buyer, or the seller can pay for it. I would suggest asking the seller to pay for it, of course, but even if they don't, it's worth it in my opinion. If you negotiated seller repairs in the contract and they pretty much phoned it in and tried to do it themselves without having a professional to do it, it depends on the quality of the work. That presents kind of a fact issue that may or may not be easy to resolve. I would suggest this is where you want to have your contract written as clearly and thoroughly as possible. So if you're having certain repairs done, you want to qualify that they're hiring professionals to do the work, and that they're licensed and bonded in the state of Texas, and all of the above. And then you'll want to define what is considered a satisfactory repair. So depending on what it is, you just want to make sure that the contract describes it as thoroughly and accurately as possible, so that if they do try to phone it in and wing it and it's not that great, you can go back to your contract and point to what you agreed to and say, no, this isn't right, and force them to fix it. Yeah, so any issues with the title to the property are going to be listed out in that title commitment. That's a document that the title company prepares and issues to both the parties, but it's especially important for a buyer to review. It's essentially a preview to the title insurance policy, and that document is what protects a buyer's ownership or a homeowner's ownership interest in the property. So say a third party from out of the blue decides to file a lawsuit against you as a homeowner, claiming that they have ownership interest in the property. So long as this specific issue is not an exception to your policy, your title insurance will cover it. So it's very important to review, especially Schedule B of the title commitment. It'll list any exceptions to the policy. Have an attorney review any reference documents to make sure they're appropriate, still applicable, and file objections to that if necessary. So you'll have a certain time period to object to any of those exceptions, and then the burden shifts to the seller, and then they have a time period to resolve any of those objections, and you'll work with the title company, buyer and seller, to hopefully get things in a place where everybody's comfortable, and all of that is taken care of before closing. So whether an attorney can help prevent future property line disputes, yes. Short answer, this is really going to come back to your title commitment, which is going to be issued by the title company, and see what shows up there and what shows up on the survey. Like, is a new survey needed or done? And typically new surveys are where you might see some new issues with regard to property lines. And the survey is going to show things like where the fences are located, any utility easements, where the actual boundary is, and things like that. So if it differs from past surveys or what people's understanding of the property was, this is where you're going to find out about it. And this is where you can address it, but it's typically when you're getting into a new property. So yes, you'll want to have an attorney review whatever the title commitment has set forth, resolve that, and you'll most likely be working things out with them and your new neighbors. As we typically will get calls about boundary line issues after the fact. So this is a way to prevent it ahead of time, is just reviewing your title commitment. Yeah, so there's several types of title issues that might come up whenever you receive that title commitment document. The most common thing that I see listed as an exception is going to be the utility easements. These are fine. You might also see, like, if you have a property in an HOA, you might see like their declaration and bylaws, etc., listed as an exception. I'm going to generally leave those alone so long as they're still accurate and applicable to the property. Things that you'll need to resolve are going to be potentially like probate issues. So if the homeowner died and they didn't have a probated will, you're going to have to potentially get what's called an affidavit of heirship, and you're going to have to satisfy the title company's curiosity with who the owners potentially are, who potentially has any interest in this property. And that may be simple, or it can get real complicated. Liens against the property. So if the owner has like a tax lien, they owe debt to the IRS, or say they didn't pay a bill to a creditor, and anybody files what's called an abstracted judgment against the property, so they receive a judgment in court, and to protect their interests in this debt, they'll file the abstracted judgment in the county records. And Any property that's in that county automatically has a lien on it, so that whenever it's sold, they get paid off first. So that's typically not going to be a huge issue for you as a buyer, because so long as the value that's going to the seller exceeds the amount of the judgment, it's going to be paid off by the title company anyway. Boundary issues, I mentioned that with the survey, you may discover that once you get into the title commitment, and so you might have to work something out with a neighbor via boundary line agreement. I mentioned lawsuits. Another thing that could come up regarding lawsuits would be what's called a lis pendens. So that is a document that's a lien specific to that property. So when I mentioned abstracts of judgment, those are general liens on any property to repay a creditor. A lis pendens is going to essentially mean that this property is subject to litigation, and that's going to have to be resolved before you can take ownership of it. The last main category that I'm going to look at on a title commitment is going to be if there are any mineral rights issues. So in Texas, this comes up a lot. You'll have leases dating back decades that may or may not still be impacting the property. So you'll want to take a close look to the actual terms of the leases and see if they're there, see if the mineral rights have been severed and who owns them, and do those parties still have access to come on the land and start drilling, because that's not a surprise that you necessarily want. So what can you include in an option period, and if there are structural issues or other issues, are you able to terminate the contract? So let's first take a step back and define what is an option period. That is a relatively short amount of time that's I would say usually 7 to 10 days, but it can be longer or less, where the buyer can have inspections performed. And that's typically, now in this market, it's a little different because the seller may not want to agree to an option period, say if they've got a whole bunch of offers. But if you have been able to get your seller to agree to have an option period, you pay what's called an option fee. That's a small amount of money, I'd say just a few $100s. For this time period, to bring in your inspectors and look at anything you want, honestly, in the property. What you'll typically do is just have a custom inspection done, where they're looking at the walls, they're looking at HVAC, plumbing, anything that they can really see on the outside, where you get. And they will look for foundational issues from the outside. Now, anything that you can't see or can't really get to, that's, if you have cause for concern, you can ask for time to do additional inspections. You can also negotiate what's called an environmental inspection, and there's a separate addendum that you'll want to include with your contract. If you have cause for concern that there might be like environmental damage to the ground, say from like if there was oil and gas operations on the property, or if there was a gas station next door, or anything like that. Again, you'll have a certain time period within which to do this. You'll want to bring in qualified professionals, and you'll want to have the consideration, which is the option fee, paid, because otherwise you don't have an enforceable contract as to that particular aspect. And then the question was, can I back out? You can back out for literally any reason during an option period, so long as that's what your contract says, and that's what the standard TREC contract is going to say. I would want to keep as much flexibility as a buyer as you can. Again, everything's negotiable, so it's going to come down to what is a seller willing to accept, and then what terms are you willing to be bound by as a buyer. Okay, so your offer has been accepted, and the seller comes back to you wanting to renegotiate the sales price or maybe other aspects of the contract, because now they've got a higher offer from someone else, and maybe a sense of what we'll call here buyer's remorse. Can they do that? So negotiation is always on the table. One cool thing about contracts is so long as the terms are legal and enforceable, any two parties can resolve something through contract and write down the terms that are agreed. Now, I think the question means more: does the buyer have any option? Like, can they maybe cancel on the buyer just because they have a higher offer? Probably not if they're using the standard TREC contract, which TREC is the Texas Real Estate Commission. They have their own forms that most people will be using unless they've hired a lawyer to write a custom one. And the reason for that is with the standard 1-to-4 residential home sale or purchase agreement, there's a specific performance clause within the termination and dispute resolution descriptions. So what does that mean? A specific performance clause means that you can force somebody to do something. So as the buyer, your options whenever the seller breaches the agreement are to either accept your earnest money back and move on and call it a day, or to enforce specific performance, which means you could sue them in court to enforce the terms of the contract as they are written. Does this happen very often? Absolutely not. I've never seen it in a residential context, and even occasionally, very rarely, in a commercial context. But it's still there, and so you still do have that option. If they're wanting to raise the price, you might consider agreeing to that, but in exchange for what we call seller concessions, where they're giving a credit towards your closing costs, which may end up being better for you in the long run. Just depends on your loan and how long you're planning to own the property and that sort of thing. But again, anything's negotiable. Whether or not you have to agree to it, that's another story. I would suggest visiting with a real estate agent and real estate attorney before making any decisions there. Okay, so you're buying a home from a builder. A lot of people are doing these days. Can you make changes to their contract? That's a great question. Yes, if they agree. So anything is negotiable in contract world, and it never hurts to try. I am not seeing a lot of builders who want to make changes to their contracts these days. It still is a great idea to have a real estate attorney review the contract before you sign. So yes, you can present requested edits. Even if they say no, you'll at least be familiar with the terms of your agreement and whether or not you can take on that amount of risk. In Texas, there are two primary types of shared ownership, and when I'm talking about this, I'm talking about people who are not married to one another, because that's another category, and I'll get to that in a minute. But so if, like, say you and a sibling own a piece of property together, the default scenario is going to be what's called a tenancy in common. That's where two or more people are listed on a deed. And if anything happens to any of the people who are listed and they pass away, that person's interest passes on to their heirs. So if they have a will, it goes to the beneficiaries named in the will. If they don't, it goes to their default heirs under intestate succession. So these party number two is still owning their, let's say, 50%. With the heirs of party number one. So it can get a little bit more complicated. The other type is what's called a joint tenancy with right of survivorship. So you have to have specific language in the deed to have one of these. But basically what this means is if I'm sharing a property with my sister and I pass away, that she absorbs my 50% interest and it just becomes hers outright. So this can be a situation where if you have like unmarried couples and they each want the other person to easily continue to own 100% of the property if something happens to the other person, joint tenancy with right of survivorship could be a good resolution for that. Again, if you don't have that language in there, it's automatically a tenancy in common, so it would get more complicated. I mentioned couples who are married because in Texas we have a concept called community property, meaning that anything that is acquired during the course of the marriage, unless you have a written agreement otherwise or barring certain exceptions, everything is 50% owned by either spouse, whether or not their name is on a deed. So if I buy a house in my own name, I'm married, my husband has a 50% ownership interest in it automatically, unless we have an agreement to the contrary. If we're both listed on a deed for our primary residence, if I pass away, he's going to, of course, the terms of my will are going to apply too, but he's essentially going to have 50% of my ownership interest in that as well. So if these are things that you're thinking about, purchasing or sharing property with anybody else, a partner, a sibling, a friend, if you're wanting to go in on something together to take advantage of the market, definitely talk to an attorney first, both a real estate attorney and probably an estate planning attorney, because this is where these issues can overlap. Texas Legal is a statewide nonprofit legal benefit plan that was founded by the State Bar of Texas in order to better meet the legal needs of Texans. They provide members with access to over 400 network attorneys and offer various insurance plan options. With Texas Legal, representation for residential real estate property is covered, so please contact Texas Legal for more information on your planned benefits. Their website and phone number will be left in the comments and description box of this webinar.